In the last 8 months, there have been 3 separate lawsuits filed by American conservative organizations targeting Native Hawaiian programs and institutions. Programs that exist to address the housing insecurity, education and chronic health disparities, and economic marginalization that Native Hawaiians face as a direct result of colonization. And none of this is a coincidence. Earlier this week, on June 1st, 2026, a group called Pacific Legal Foundation filed a federal class action lawsuit in Honolulu, challenging the Hawaiian Homes Commission Act, specifically the blood quantum requirement. For background information, the Hawaiian Homes Commission Act was passed by Congress back in 1921, largely through the tireless advocacy of Prince Jonah Kuhio Kalanianaole, a former prince of the Hawaiian Kingdom and, at the time, Hawaii's delegate to Congress. Kuhio had watched his people be systematically dispossessed by their land following the illegal overthrow of the Hawaiian Kingdom in 1893 and the forced annexation that followed. Native Hawaiians who had lived, farmed, and set roots on their ancestral lands for generations were being pushed out, displaced, and dispossessed. Kuhio had fought for years to get some of that land returned, and what he got was a compromise. Not even a good one. The most fertile, valuable agricultural land was carved out and kept by the sugar plantations. What remained, about 200,000 acres of largely rocky, dry, and remote land, was set aside for the Native Hawaiian homesteads. It was inadequate from the start, but it was something. The Hawaiian Homes Commission Act reserves those 200,000 acres for 99-year homestead leases at $1 a year, but only for people who can prove they are at least 50% Native Hawaiian by blood. And now it is being litigated out of existence. Pacific Legal Foundation is a Sacramento-based conservative legal nonprofit. They were founded in 1973, and its original staff was composed mainly of individuals who had been part of Ronald Reagan's welfare reform team. They were built to roll back government programs for vulnerable people, and they've been doing exactly that for over 50 years. They describe themselves as fighting government overreach and defending individual liberty, but in truth, they go after affirmative action programs that benefit Black and brown students, tenant protections that keep people housed, and environmental regulations under the Clean Water Act that protect wetlands and waterways. They were the first organization to sue to block student debt cancellation for over 40 million Americans, and they used the Ku Klux Klan Act of 1871, a law that was passed to protect Black Americans from racial terror, to sue UC San Diego over a scholarship for Black students. They have won 18 of 20 cases they've taken to the United States Supreme Court. Their annual budget is over $25 million. They have more than 100 staff attorneys across 3 offices, and one of their current trustees, John Yu, is a UC Berkeley law professor most infamous for authoring the so-called torture memos for the Bush administration after 9/11, which provided the legal justification for the CIA's use of waterboarding and other enhanced interrogation techniques on detainees. Federal courts and legal scholars have widely condemned those memos as a grotesque distortion of constitutional and international law. The local Honolulu attorney attached to this filing is Kevin O'Grady. His practice is DUI defense and Second Amendment litigation, running a separate website called HawaiiGunLaw.com, and is a life member of the NRA and Gun Owners of America. He has no background in Hawaiian land rights, indigenous law, or Native Hawaiian history whatsoever. The actual legal work is being done by Pacific Legal Foundation's attorneys from Sacramento and Virginia, while the only Hawaii connections to this entire lawsuit are the plaintiff Eric Ryan, a Hawaii resident that is not Native Hawaiian, and Kevin O'Grady, the gun rights DUI lawyer whose name appears on the cover page to satisfy court filing requirements. Again, their plaintiff is Eric Ryan, a non-Native Hawaiian resident of Honolulu. He is a man who has not been dispossessed of anything, who carries no historical relationship to this land, attempted to access a program specifically built to address the ongoing consequences of a colonial land theft that did not affect him or his family, and when he was denied, he became the perfect plaintiff for yet another conservative organization in this coordinated campaign to strip Native Hawaiians of our lands, our institutions, and our legal protections. Pacific Legal Foundation is arguing the Hawaiian blood quantum requirement violates the Equal Protection Clause of the 14th Amendment and the Due Process Clause of the 5th Amendment, and they lay out their constitutional argument explicitly in their own complaint. Native Hawaiians are not a federally recognized tribe, and there's no federally recognized Native Hawaiian tribal government the way there is for, say, the Navajo Nation or the Lakota. Under federal Indian law, Congress has wide latitude to create programs that benefit members of federally recognized tribes because that's a political classification, membership in a sovereign government, and not a racial one. But because Native Hawaiians don't have that federal recognition, Pacific Legal Foundation is arguing that any program targeting Native Hawaiians is just racial discrimination, period. And racial classifications have to survive strict constitutional scrutiny. The absence of a federal recognition for Native Hawaiians is not by accident or an oversight. It was intentional. The Native Hawaiian Government Reorganization Act, known as the Akaka Bill, was first introduced in the year 2000 by Senator Daniel K. Akaka of Hawaii. The bill's stated purpose was to establish a process for the reorganization of a Native Hawaiian governing entity and the reaffirmation of the special political and legal relationship between the United States and that governing entity. In other words, a formal government-to-government relationship. The same political status that protects tribal programs from exactly these kinds of constitutional challenges. It would have extended to Native Hawaiians the same right to build a government-to-government relationship with the United States already held by the 575 federally recognized tribes across the continental U.S. and Alaska. The Akaka Bill passed the House multiple times but died in the Senate, blocked largely by Republican senators using the argument that it would create a race-based government. Now this same argument is being used in court to dismantle Hawaiian programs. The United States blocked every path to federal recognition for decades, and now the absence of that recognition is being used as legal justification to take more land away from Native Hawaiians. And here is where it all connects to the bigger picture. Back in October 2025, Students for Fair Admissions, a Virginia-based organization founded by Edward Bloom that killed affirmative action at Harvard and other colleges, sued Kamehameha Schools over its Native Hawaiian admissions preference. 2 of their 4 plaintiffs didn't even have the test scores to reach the stage of the process where Native Hawaiian preference is considered, and the other 2 never applied at all. Then in March 2026, Do No Harm, another organization where Edward Bloom serves as director and treasurer, sued to dismantle the Native Hawaiian Health Scholarship Program, a 30-year-old federal program that places Native Hawaiian doctors and nurses in medically underserved communities across our islands. Their plaintiffs are 3 anonymous members of Do No Harm who tried to apply, but because they're not Native Hawaiian, aka they don't qualify for the program, they were denied. 3 lawsuits in the span of 8 months, all from American conservative organizations targeting Native Hawaiians. And they are doing all of this in the context of a Trump administration that has been actively hostile to Indigenous rights, DEI programs, and anything that acknowledges that some communities carry the specific historical weight of colonization and dispossession. There are over 29,000 people on the waiting list for DHHL leases. Some of them have been waiting for several decades. People have died on the waiting list. The Hawaii legislature allocated $600 million in 2022 just to try to address the backlog. If Pacific Legal Foundation wins, meaning if the courts agree that the blood quantum requirement is just racial discrimination, then the Department of Hawaiian Homelands as we know it is done. And all of that land doesn't go back to Native Hawaiians in some other forms. It becomes publicly available land to the state of Hawaii as part of the United States of America. And in Hawaii's housing market, we know exactly who's going to end up with it. On Tuesday, June 3rd, Hawaii Governor Josh Green responded saying he's directed the Department of the Attorney General to vigorously defend the Hawaiian Homes program, and said that the state will fight this lawsuit with everything it has. Attorney General Ann Lopez added that the state has both a legal and moral obligation to uphold the Hawaiian Homes Commission Act, and that Solicitor General Kaliko Onalani Fernandez, who has extensive experience in complex constitutional litigation, will lead the defense. And because all of this is about blood quantum, of course I have to talk about this. Blood quantum is a colonial tool invented by the federal government to shrink the number of people who qualify as Indigenous over time. Indigenous scholars and activists have been critiquing blood quantum for years, for decades, as a mechanism designed to make us disappear. So the fact that a conservative law firm defending a non-Hawaiian man who just wanted cheap land is now using that same critique to dismantle the last protections Kanaka Maoli have under that system is honestly one of the most manipulative things I've ever seen. The critique of blood quantum belongs to Indigenous peoples. It is not a weapon for haole men or haole organizations to use to finish the job of dispossessing us.